My name is Thomas Lindsay, and I'm Senior Counsel for the Center for Democratic and Environmental Rights. We're here today talking about the 4 legal doctrines that interfere with people doing work at the local level to expand rights for or protect the natural environment and the community. So people working within their communities who are dissatisfied with federal or state environmental law and begin doing work at the local level to expand out environmental protections in their cities, towns, villages, or counties run into a doctrine called Dillons Rule to stop them from doing what they're doing within their cities, towns, villages, and counties. That doctrine is that the municipality that they live in, their city or town, is a municipal corporation. And as a municipal corporation, it's wholly subservient, wholly subordinate to the state government. That the state government creates municipal corporations, which are your cities, towns, villages, and counties, and the state can abolish them at the will of the state. It always sounds kind of strange to think that way, but your city or town is an actual corporation, and that corporation's powers and exercise of its authority is defined fully by the state. And so what the courts talk about is that the state is the parent and the municipality is the child. And the state has plenary authority to do with the child whatever it thinks is most useful. And that may include abolishing it or joining it with other municipalities or taking away its powers from time to time. What's the history of Dillon's Rule? Well, Dillon was Iowa Supreme Court justice who used to work for the railroad corporations. And the railroads were concerned about people in cities, towns, villages, and counties interfering with the railroads running their lines westward. And so to keep the railroad corporations from being interfered with by local laws or decision-making by these cities and towns, that John Dillon, who was the Chief Justice of the Iowa Supreme Court, who Dillon's Rule is named after, came up with this rule, which said that municipalities didn't have any lawmaking authority except that which specifically was given to them by the state. And that's the situation that we're in now, which is if your city or town has not been told by the state that it can ban fracking or stop factory farms or stop any of the bad stuff that's coming into your particular municipality, then by default it does not have that power. That's the Dillon's Rule concept. Dillon's Rule did battle for a number of years with equal doctrine called the Cooley doctrine, which was from a Supreme Court Justice of the Michigan Supreme Court, Thomas Cooley. And the Cooley doctrine was different. It said that communities have an inherent lawmaking authority that can't be controlled by the state, that it's separate and independent from state authority that's used to control municipalities. Unfortunately, at the turn of the century, late 1800s into early 1900s, Dillon's Rule supplanted the Cooley doctrine. And so it's all the lawyers know about at this point is Dillon's Rule. And the question is, how is Dillon's Rule used today? Well, it's not the state necessarily coming in, the Attorney General of the state coming in to tell you that you can't do something at the local level. It evidences itself via lawsuits, where a community will pass a law to ban fracking, for example. And the corporation or another major economic actor will come in and use Dillon's Rule to sue the municipality, contending that the municipality didn't have the power to pass the law in the first place, and therefore the law needs to be overturned. Folks in communities who are working on issues of expanding environmental protection at the local level and passing local laws to do what state and federal governments are refusing to do, which is adequately protect the natural environment or the people within the community, have been arguing that Dillon's Rule is a violation of their constitutional right of local community self-government, that they have a right akin to the Cooley doctrine stuff that disappeared over 100 years ago, that they have a right to actually govern their own community, a right to pass laws to protect themselves at the local level. And so they're arguing in courts that Dillon's Rule itself is unconstitutional because it violates their constitutional right to govern their own community in the name of their health, safety, and welfare. Now, a lot of people think that home rule, which is this concept given to municipalities that have their own charters, and many municipalities in the U.S. have their own charters today, which are like local constitutions for those cities, towns, villages, and counties. that somehow that just because you're a home rule municipality, that you're exempt from Dillons Rule. But it's not really true, because even if you're a home rule municipality in the United States, that the state can still override your lawmaking authority. It's more difficult for them to do so, but you're still in the same place as even non-charter municipalities are in terms of state control over the laws that you can and cannot pass. And so Dillon's Rule has been used a number of times over the last 30 or 40 years to stop municipalities and stop people within those municipalities from adopting more stringent environmental laws than the state provides. So this constitutional right of local community self-government, a lot of people ask, where does it come from? And it turns out that for about 100 years, the courts have recognized a constitutional right of local community self-government. And then that series of precedent, those court cases, basically fell by the wayside when Dillon's Rule began to supplant the Cooley doctrine in the United States. But there's a vast history of not only court precedent, but scholars and lawyers who have made arguments around this constitutional right of local community self-government. It exists today both in the state constitutions where political authority is vested in the people themselves. Goes back to James Madison's amendments to the U.S. Constitution, where he attempted to insert the Declaration of Independence principles directly into the U.S. Constitution. The Declaration of Independence, of course, provides that governments are created to protect rights, and that when governments stop doing that, that people have the authority to come in and abolish the government and create new forms of government. So no matter where you look, this power of people to have the inherent authority to govern themselves within their own communities is this strand that ran through the American Revolution, which was basically about self-rule against Britain, and all the way through the culmination and development of these major documents in U.S. history, including the Declaration of Independence, the U.S. Constitution, and eventually the state constitutions that were written, which embody this concept of a right of self-governance.